Hello, everybody. I'm Nate Eaton with East Idaho News. It is Monday, and we are 1 week closer to the trial for Chad and Lori Daybell. Ironically, I was thinking this morning that had the original schedule, well, one of the original schedules gone on as planned, we would actually be in week 2 of the trial. You might recall that the trial was originally set to begin January 9th, which would have been last Monday, and it has now been pushed off to April. But I did want to fill you in on a bunch of new court filings that were filed just last week, the end of last week. Some interesting nuggets in some of these documents. We're going to post a story shortly here on eastidahonews.com. Some of the main interesting elements that I found as I went through all of these over the weekend is that prosecutors say they have, quote, sufficient evidence that shows Lori Daybell intended for her 2 children and Tammy Daybell to die, and that she participated in the killings of JJ and Tylee. Let me read to you directly from this document. This was in a response that Lindsey, Blake, and Rob Wood filed to Jim Archibald and John Thomas. Those are Lori's attorneys. You might recall that they asked the judge to take the death penalty off the table. They said that prosecutors had not clearly and narrowly presented their argument as to why Lori Vallow deserves the death penalty. And the prosecutors were responding to this argument saying she does deserve the death penalty. And in one part, they said, sufficient evidence existed for the grand jury to find probable cause that the defendant, Lori Vallow, intended for her children and Tammy Daybell to die. Further, there is sufficient evidence for a jury to conclude that the defendant participated in the killing of her own children. Blake goes on to say that the facts in the case are, quote, egregious and heinous. She says, the evidence the state will introduce at trial, some of which a grand jury has already reviewed, will establish that the defendant intended for her children and her boyfriend's wife to die, and that she affirmatively acted to make those deaths happen. So this is pretty, forward language, that they're saying that she actually participated in the killings of JJ and Tylee, and that she wanted them to die along with Tammy Daybell to die. Now, you might recall a few weeks ago that her attorneys filed a motion or a notice of alibi saying she was in her own apartment and that her children died in her brother's apartment, Alex Cox's apartment. They were very close to each other. They lived in the same complex. And that was her alibi. And that when Tammy Daybell died, she was in Hawaii. So interesting note here that that's what her attorneys are saying. She doesn't deserve the death penalty. Prosecutors are saying she does deserve the death penalty, and we're going to prove that there's sufficient evidence here to say that she participated in the death of both of her children and that she was very well aware of Tammy Daybell's death. We have another court filing that came down. You remember that her attorneys asked that she could meet with Chad, that they could discuss strategy and potential settlements in the case, that maybe they talk about some sort of agreement or whatever. And that was filed, and it was interesting that the prosecution did respond to that. They didn't flat out object. They're not flat out saying, no way, we do not want Chad and Lori to meet. But they do raise some concerns here. And they are saying that the state has serious reservations about allowing the co-defendants to have face-to-face or other communication directly with each other. The state recognizes that the defendants have agreed to not use any evidence or information they may obtained through any discussions or meetings against each other. Nevertheless, the state is not willing to make a similar agreement. So basically what Lori's attorney said is, can Lori and Chad meet? We won't record the calls. We won't record the conversations. It won't be used as evidence, won't be used in court. It'll just be for the purposes of us meeting, maybe discussing, a plea agreement, whatever discussions might be for a settlement. The state is saying, we have reservations about that. And while you're saying that you won't use any evidence or information against each other, we're not willing to make that same agreement. Rob Wood also writes that any communications between each of the defendant and their attorneys are confidential. You know that if you have an attorney, communication between the two of you, it's confidential. It's attorney-client privilege. You can tell them, and that can't be used against you in court. But Robert goes on to say, however, having the other defendant and or his or her counsel present would make them potential witnesses of statements made by the other defendant and eliminate the attorney-client privilege. Now, I'm not an attorney, but this is how I read it. If I'm Chad's attorney and I'm there with Chad, we have attorney-client privilege. What we say is confidential, can't be used against me. It's our attorney-client privilege. But if I witness Lori say something, I'm not her attorney. So there's no attorney-client privilege with me and Lori. Therefore, if Lori says something incriminating or says something damning or whatnot, I've witnessed her saying that. So how does that fall? And that's basically what the prosecutors are saying here, that you're not as protected against that. At least that's how I read it. Again, the prosecution's not completely objecting to the idea of the Daybells meeting, but prosecutors are asking Judge Boyce, who will ultimately decide if they get to meet or call each other. They're asking Judge Boyce to please, consider these objections that we have raised. All right, another filing, DNA testing. It looks like the state lab did find some hair samples, which we know about. I'm assuming it's the hair samples that were mentioned in court filings last July. It was hair from the duct tape inside the body bag that was used to transport JJ's remains. They want to get it tested, and they're saying that if they do get this hair tested, it might be consumed or destroyed right after the test. They're trying to see if there's some DNA profile that this hair can match with. So they're basically notifying the other attorneys that we have the hair, we want to get it tested, it's possible it could be destroyed after the test, but they're saying if the DNA is able to create more than one profile, then we'll split it between the parties for testing. So each party could decide who's going to test that hair. So Lori's team would get a sample, Chad's team would get a sample, the state would get a sample, they could each hire their own independent lab tester if they wanted and find out what DNA is on it. If they're able to get, individual samples from it, or profiles, I should say. If there's sufficient evidence that DNA is only available for one profile to be created, then before they go any further, all the parties will get together and decide who will do the testing and if they can agree. Prosecution and the defense, they each have the right to do their own testing on evidence and DNA testing. Obviously, that's how they kind of poke holes in each other's arguments. So that was filed. Finally, two other motions that were filed. Both Chad and Lori's team object to having a jury sequestered. The prosecution wants the jury sequestered, and if you can imagine being sequestered, not being able to, have contact with your family, get online, whatever, for 8 to 10 weeks, that could be a long time. And that's exactly what the defense is arguing, that it's too long, it's unnecessary. And because the judge ruled that cameras aren't allowed in the courtroom, the defense is saying that pretrial publicity has gone down, so there's no need to do that. And so they're asking that, no, we don't want the jury sequestered. It's just fine how it is, or not having them sequestered. Also, the prosecution objects to John Pryor. You might recall that he has asked to have the trial pushed off till April of 2024, so another year. Prosecution says no. John Pryor says he's simply not ready. There's so much evidence here. And what they've said is that the prosecution said the counsel, John Pryor, has represented the defendant for over 3 years regarding the allegations which are part of the case. Presumably, given the length and nature of the representation, it would seem that the defendant has had adequate time to consult with his counsel and provide him information necessary to obtain any relevant documents and evidence. Now, all of this will be argued in front of Judge Boyce Thursday. I'm going to be there. The hearing starts at 9. Unfortunately, we will not have a live feed. I wish we did, but I am going to request the audio the second the hearing's over so that you all can listen to it if you want. And we're going to hear the motion about jury sequestration, the motion to continue until next April, the motion about whether Chad and Lori should be able to meet together and what kind of how that should work out. Also, the other motion about the death penalty. So there you go. Someone said, how long can this go on? You realize we're going into, it was 3 years ago this very week that we learned Chad and Lori were in Hawaii, and we started to plan our trip over there. It's so crazy to think about and flashback. That was 3 years. Pre-COVID, a lot of stuff's happened in 3 years. And who would have thought we'd still be here 3 years later? So yeah, it has gone on a while, but we're going to continue to cover it. I guess there's a chance that there could be some sort of plea agreement before April. There could be some sort of agreement, or it could full on go to trial. I mean, Lori has not waived her right to a speedy trial, so she appears to want to have this trial happen and get it done with. Another question, kind of switching topics. Several of you have asked why I'm not covering the University of Idaho, the horrible case up in U of I. That's about 8 hours away from us, and physically we just can't go there. I mean, obviously, if that happened here in Rexburg or Pocatello or Idaho Falls, we would be all over it. But there are plenty of wonderful, talented reporters who have been covering it thus far, and so we're using a lot of their coverage. That's why I personally am not covering it. I did happen in Idaho. I got an email over the weekend saying, why are you covering this? We are covering it, but just me personally, I'm not covering it. The thing is, I asked last week, someone just said, well, what if there's not cameras in the trial? That's up to the judge. It's 100% right on what the judge wants to do. If there are not cameras, then I'm planning to maybe, if you're interested, do a nightly recap video, kind of like what I'm doing with you right now. Every night, fill you in on what's happening and let you know what happened that day at trial, if you're interested in that. If nobody watched, I wouldn't do it, but if people wanted to watch, because I know all of you can't go to Boise for that, then we'll see. We'll see if I would love it if the judge suddenly said, we're going to let cameras in or a live audio feed, something. But if he doesn't, I'm happy to fill you in if you would be interested in a live audio, like a live video, and maybe you all could ask questions, and we'll see. So thank you all for watching. Again, I'm going to post a story here shortly within the next few minutes on eastidahonews.com. You can go read everything I recapped here and all about the new court filings. And the trial is allegedly less than 3 months away. So we'll see what happens. Next hearing is on Thursday. We'll have a full recap, and I'll probably do go live after the hearing when I come out of the courthouse, just like I am right now. Hope you have a good week. Thanks.